Hey everybody, Yaasha Sabba here. How are you doing? Welcome to Ask Me Anything. We're going to answer your estate planning and asset protection questions, starting with question 1. What are my rights to my deceased husband's property when his adult children from a previous marriage have moved into the house? All of our assets were accumulated during our marriage. I left the home because there was marijuana being grown and sold from the house, and my deceased husband and I have a 15-year-old daughter. All right, first question I have to ask for you is, who's on the title of the home right now? Is it you and your husband? Why did you leave the house, and why didn't you kick his adult children out? So this is something we got to figure out. You should either hire an attorney to probably figure it out for you. Really, if the house belongs to you, whoever is living in it right now, even if you're not living in it, they are considered your guests or your tenants. So if you want the adult children out, you just take them through an eviction process. It's that easy. Get an attorney and kick those marijuana dealers out. All right, next question. Should I allow my dad to add me to the deed of our family home? What potential liability or risk is involved? There's still a mortgage on the home, an equity loan on the home, along with other debt my dad owes, and my husband and I are looking to selling and buying a new home in the next few years. So a lot of parents, they do this as a kind of a measure of estate plan, kind of a pseudo estate plan. They add their children's name to the title of the deed. So if something happens to them as joint owners, your children will become automatically vested in the title of the home. There's an upside and downside to that. The upside, you avoid probate, you avoid court process, you avoid having to hire attorneys. It's nice and easy. The downside, there's a mortgage on the home. Do you think the bank will be happy with dad adding another person to the title of the home? Most likely no. A bank could call that a transfer, and in the mortgage there is an acceleration clause that says the entire balance of the loan becomes due upon the moment of transfer if you don't ask the bank's approval first. So if your dad is going to do this, you need to call the bank and get them to approve. Most likely what's going to happen, the bank will want to add you onto the mortgage, add the debt onto your name as well. So sometimes that doesn't happen. If your dad has enough money and he's paying back the loan and his credit score is good, they'll say that's fine as long as your dad continues to pay. We know that families do this for estate planning. Another thing that will happen is, now you've got debt tied to your name. When you go to try and buy a new home for you and your husband, this debt is also associated to you. It's associated to your credit score. Another thing that also happens, the thing that I care about the most, that I don't like about parents adding their children to the title of joint owners as home, is your dad is going to give you, as his daughter, 50% of his cost basis, the original purchase price that he purchased that home. Now, why is this important? A lot of people miss this, and it is such a huge tax savings if you don't do this. When you inherit the cost basis of your dad's home, so let's say your dad bought his home $300,000 20 years ago, and let's say the home is now worth $1 million. When your dad gifts half of the interest of the home over to you so that you and him are co-owners, he's gifting half of that cost basis, half of that $300,000 original purchase price that he purchased the home at. What does that mean? You will be the new owner of the home, and your cost basis, your original purchase price of the home, will be $150,000, and your dad's will be $150,000. So when you both decide to sell the home, or when your dad passes away and you inherit his half of the home, his portion of the home, his original cost basis, will jump up at the time of his death to the original price. And let's say when your dad passes away, it's $1 million, the value. And then your portion stays that $150,000. So if you end up selling the home, you're going to pay taxes on half of the value of gain minus your original cost basis. So you're going to have to pay capital gains taxes on a little over $300,000. Maybe $250,000 will be credited to you because the IRS credits each one of us up to $250,000 individually from gains for homes that we sell, especially if it's your primary residence. Is this going to be your primary residence? Are you going to have to pay tens of thousands of dollars in taxes when you sell? What might be better is your dad has two options in creating an estate plan. First, your dad can create a transfer on death deed and record that, basically a beneficiary designation for your home. Instead of transferring title to you, he can record this special deed that is called a transfer on death deed here in California. And when your dad passes away, you automatically get full title of the home without any court proceeding. You just file a death certificate with your county recorder's office. And because it's being transferred to you at death, you're getting it as an inheritance, not as a gift. gift. When your dad dies, the full value of the home becomes your original cost basis at the time of death. So instead of you inheriting a cost basis of $300,000, you inherit the fair market value of the home. So if you sell that home right then and there after your dad passes away, no taxes. Isn't that huge? You save tens of thousands of dollars. What would you do with tens of thousands of dollars? I would like a bloody red Corvette. That's what I would do with my savings. Maybe not. Maybe I invest it. Maybe I put it in cryptocurrency. The point is I have options. But if you are paying that tens of thousands of dollars while you have been gifted that home and then you sell it later, even while your dad's still alive, you're losing so much money in taxes. Why would you do that? Option number two, something to keep in mind. This transfer on death deed, this law is an experimental law that California passed a few years ago. It was only meant to last 3 years. We don't know if the state legislature is going to extend it. The law expires this year. So if your dad's gonna do this, now is the time. You need to file a transfer on death deed before January 1, 2021. So make sure he gets that done. Otherwise, what's a little bit more secure, what's a little bit more structured is your dad creating a trust. When you have a trust, you avoid court, you avoid probate. So your dad moves the home into the trust, and in his trust, he can say, give the home to my daughter. The exact same thing as the transfer on death deed. The difference here though, is there's a lot more protection your dad can build in for you, legal protection. So this is what should have been a short question, gets very long because I see families doing this all the time and they don't understand the tax consequences to their loved ones when they just gift property, especially very expensive assets like a home, over to their kids. Instead, your dad can file a transfer on death deed, very cheap and easy to do, or your dad can build a trust, which gives him a lot more security, gives you more privacy, and your dad can build in legal protections for you. So when you inherit this home, it remains your separate property. It doesn't become a part of your husband's property. What happens if you and your husband get divorced when you inherited this home? Is it a part of your marital estate? Did you do something accidentally that transmuted it into a community property? These are real legal risks, and you're not a lawyer, and I'm not expecting you to know how to handle everything, but your dad can handle it for you with a trust. So something to keep in mind. If your dad wants to talk about that, you're more than welcome to send him our way. Any other questions? Send them our way and we'll answer them during our Ask Me Anything.